Trinidad and Tobago and Daban.
My lords, my ladies, I appear on behalf of the appellant instructed by BDP Pitmans, Mr. Elton Prescott, Senior Counsel, and Mr. Christopher Sushand of the Trinidadian and Tobago Bar appear instructed by Charles Russell Speechleys for the respondent. As the board will have seen from the statement of facts and issues, this appeal concerns an allegation of unequal treatment arising from the respondent's failure to re-employ the appellant as a permanent worker. The board has the agreed facts at pages 511 to 513 of the electronic record and the agreed issues at pages 520 to 521. In the appellant's submission, the main issues...
Well, now, before you get to the main issues, Mr. Poole, the respondent makes a case that you have reformulated the appellant's case and that you advance an appeal which is quite different from that which was considered by the Court of Appeal and the trial judge, and that there are two fundamental objections to that. First, that there may well have been evidence that could have been adduced to confront the arguments that you now wish to deploy, and secondly, that the board would have benefited from judgments in the courts below on these issues, and that on that account you should not be permitted to advance them. So perhaps you can deal with that in the first instance.
My lord, yes. By way of preview, what we say to that is that the appellant will demonstrate that, in fact, there has always been two aspects to the claim for unequal treatment. The first aspect being that the comparator, Mr. Hippolyte, was re-employed within 1 month of his release from prison, whereas it took the respondent 11 years to re-employ the appellant. We say that has always been an issue in this case, and that is what I call the delay point in the printed case. And the second aspect...
Yes, but that was an issue that was not explored below. I mean, there was no investigation, for instance, as to whether or not
my lord,
the deceased had renewed his application for employment, or whether he'd simply allowed the inaction of the respondent to lie.
Sorry, my lord.
Well, in other words, he applied to be re-employed. He wasn't re-employed, and it may well be relevant to discover whether or not he had done anything about that, or whether he'd simply acquiesced in that.
My lord, I will demonstrate that, in fact, as this was always part of the constitutional motion, which the respondents met with its evidence. In my submission, I say there was an investigation insofar as the respondent put in evidence to meet it, and there were findings made by both the first instance judge and in the Court of Appeal on delay. And I'll demonstrate that by reference to taking your lordship through, and my ladies, through the motion itself, the affidavit put in support by both the appellant and then what was put in by the respondent in response, then the first instance judgment in the Court of Appeal. And it may assist if I do that sort of first up.
Mr. Poole, I mean, picking up my Lord's point and developing it, if I may, briefly, we see the declaration that was made by the trial judge. We've got it, the 388. You know it off the back of your hand. It's a declaration about 1980. Then we read your case, and at 33, we see you claiming an entitlement to a declaration in alternative form relating to 1969. And we say to ourselves, the declaration you got was re-1980. There was no cross-appeal that you should have been entitled to another, bigger one to the Court of Appeal, and that you're now, as is suggested by the respondent, greatly enlarging the ambit of the appeal.
Well, my Lord, if I can meet that point head on, I say, of course, the declaration that your Lordship recognises at page 388 is a declaration that relates to re-employment from 1980. I say the declarations that the judge made do not accurately reflect the findings that the judge made, and that is seen writ large if one looks at paragraph 39 of the judgment, where the learned judge says, 5 lines up from the bottom of paragraph 39, "This court therefore holds that the respondent treated the applicant unequally in delaying his re-employment and also in not re-employing him at the position that he formerly held." Now, the delay in his re-employment, in my submission, can only relate to, and one sees that when one looks at the judge's factual findings earlier in the judgment, can only relate to the period 1969 to 1980. And
Mr. Paul, I mean, surely appeals are against orders, not the reasoning of the courts. And my Lord has pointed out the order that was made at 388, which is confined to the 1980 period.
My Lord, I of course recognise that the order was made, but I submit that the order was made, in my submission, there is no good reason why the order was confined to what is effectively the second part of that finding that I was referring, my Lord Wilson, to at paragraph 39.
But then that would have been grounds for a cross-appeal, but there wasn't a cross-appeal.
My Lord, the Court of Appeal well understood in my submission that the issue of delay, or the delay point, the period 1969 to 1990, was an issue, and we see that from the findings that the Court of Appeal made. So, my Lord, of course, I recognise that there was no cross-appeal. I can't explain why there was no cross-appeal other than to observe that the parties understood, as did the Court of Appeal, that the delay point was in issue. And in my submission, given that there has been a finding of a breach of Section 4D of the appellant's constitutional rights in respect of this period of delay, 1969 to 1980. That is what the judge finds at paragraph 39. And when one looks then at the Court of Appeal also look at the respondent's justification for that and find that there is no justification. What the board has is a sort of unvindicated, unremedied breach of Section 4D of the Constitution. And in my submission, I say, firstly, this isn't a new point, it's always been an issue. I say, even if it is a new point, then it would be grossly unjust if the appellant were not permitted to advance it before the board. And I will engage with the point my learned friend's advance for the respondent, that it would require a further evidential inquiry. I say, with respect, that's just wrong, because the only evidence that went to the period 1969 to 1980 was the respondent's error. The respondent's case, both at first instance and in the Court of Appeal, was they believed the appellant was abroad and unavailable for work.
You've got a rather more fundamental point, have you not, in that your case is that as submitted, the original case made on behalf of the appellant was that there was a delay from 1969. That afforded the respondent the opportunity to adduce evidence, if there was any relevant evidence, to deal with that. And you can't really fasten on the finding of the court to say that the respondent was deprived of the opportunity, or that the court was denied the chance to deal with the 1969 to 1980 delay.
My Lord, perhaps if I can answer your Lordship's question by reference to some documents and as I say, demonstrate, or hopefully demonstrate, that the delay point was always in issue and was addressed by the respondent.
Well, I mean, that's the point I was making.
Yes, no, and if I can illustrate that by reference to the record. So,
we don't want to get too deep
into the minutes. No, we don't.
Do you think we ought to have briefly from
Yes,
Mr. President?
I think perhaps unless you have something other than by recourse to the documents to say to us on this point, we'll hear from Mr. Prescott.
Could I just, before we, I don't want to prolong this, but you said just a moment ago that there was no good reason why the declaration that the trial judge made was limited in the way that it was when comparing it with the previous paragraph. But wasn't the reason that that's the way it was formulated in the notice of motion?
My lady, I say the case...
I'm just wondering if you could, because I'm not seeking really to go into it, but just to point me to where in the notice of motion the case is formulated as unfairness by virtue of delay.
My lady, at paragraph 3 at page 1022, and the notice of motion appears in two places because at the beginning of the record there was an incomplete version. So the reference I'm giving your ladyship is 1022. But if your ladyship has marked up the earlier,
I'm afraid I've taken
I can give you your ladyship that reference. So it's page 11, maybe an easier reference. So these are the. He's saying in here, in 1969, upon his release from prison. And then it's the second sentence I pray in aid of. He was not permitted by the port authorities to resume his duties and then continue to make representations. So
that's the facts on which the application is based. I'm looking for the claim, the declaration.
Well, lady, there is. I can't point in paragraph, effectively what is paragraph 1 that sets out the declarations to a specific declaration. But what I can point to are the facts upon which the claim was advanced, which I say squarely put in issue the fact that he was not permitted in 1969 to resume his employment, and also the affidavits that were served by the appellant and then responded to. And for your ladyship's note, in particular, it's the second affidavit of the appellant at page 263, paragraph 14, where he says, the basis of my claim is that I was not entitled, and sorry, I've added the word not because it's clearly an omission when one reads it in the sense of that sentence. Basis of my claim is that I was not entitled to resume my employment with the respondent as a registered worker upon my immediate release from prison. So in other words, that is 1969.
Are you saying that if he'd gone straight to court and said that his constitutional rights were being infringed, gone straight to court in 1969, he could have got a declaration?
My lord, I can't say that because...
I didn't think you could.
Because his comparator is not released from prison until 1990.
Well, quite.
But I say that doesn't put me in any difficulty in terms of a proper analysis of an unequal treatment claim. And the reason I say that is really 2 points. I say the nature of an unequal treatment claim under Section 4D makes it irrelevant whether similarity of circumstances, what Lady Hale called the sameness question in Webster, arises after the treatment you complain about. And what I mean by that is that obviously in order to establish a complaint of unequal treatment under Section 4D, you must identify someone that has been treated differently to you despite being similarly circumstanced. And I say the fact that that sameness arises after the treatment you complain about should not matter when asking the question, are these two people similarly circumstanced?
It's quite a difficult argument, is it not? If the Port Authority had decided not to re-engage Mr. Hippolyte, then you wouldn't have any claim at all.
No. No.
And therefore, it's the adventitious circumstance that he was engaged immediately upon his release that allows you to rationalise back to 1969.
My lord,
there was
yes.
no unequal treatment until Mr. Hippolyte was engaged, isn't that right?
No, there was certainly no unequal treatment that the appellant could point to in 1969. But that's why I said, in answer to Lord Wilson's question, I had 2 points on this, if you like, why there is nothing irrational or unjust comparing the appellant and Mr. Hippolyte's situations, despite them being effectively 22 years apart. The first, I say, on a proper analysis of an equal treatment claim, the time lapse doesn't matter. But second, and this, I think, answers my Lord Lord-Care's question, it comes into the second stage of the analysis. It, of course, could be relevant that 22 years have passed between 1969 and 1991. If the respondent is going to say, Well, the difference in treatment is justified or explained by the fact that circumstances have changed, procedures have changed, there is different policies in play as to how we employ people or re-employ people after time spent in prison. So I say it doesn't go to the first question and the sameness question, but it can go to the justification question. But that's not the way the respondent met the delay point, because the way the respondent met the delay point, and without wishing to sort of overemphasise this point, both at first instance and also in the Court of Appeal, was to challenge the appellant's evidence that he was in the country by saying you were abroad and you were unavailable for work.
Yeah.
And the affidavit that was relied on primarily to meet this was Miss Stuart Touzon's affidavit.
I don't think we want to get into the detail of this, and of course we've read all of the material. Let's hear from Mr. Prescott on this question of whether the appellant should be permitted to advance this case. Mr. Prescott.
Our position is that the appellants ought not to be permitted to advance the case as it is now being presented. You would note from the motion itself that they came to the court seeking reliefs that were limited to, and let me use the exact language. I'm looking at the record at page 5, is it? And 17? You see that? It is set out now for the purposes of this court at pages 1016 to 1017.
1016.
Mr. Prescott, I'm having trouble hearing you.
Turn the microphone inwards.
I don't think that they amplify. I think they simply record.
So I should throw my voice.
If you would, please.
Yes, indeed, my lord. So, my lord, I was inviting your attention to the formatting of the reliefs sought.
Yes.
And they can be found at pages 1016 to 1017 of the record, of the supplementary record.
Yes.
And should I read them to you? Or?
No, we've got them. Is there a particular passage that you want to refer us to?
So, my lords, they are firstly at C.
Yes.
That he should be reinstated as at 1960.
He should be regarded as commencing employment in 1960.
Indeed, my lord.
Yes.
Well, that was reinstatement back to 1960.
Commencing on that date, yes, please, my lord. And
above, I think before arrival before the trial judge, the appellant had abandoned his case for reinstatement in the retroactive sense.
And was content.
And it might be helpful if in the course of this case we don't refer to reinstatement unless we want to refer to the retroactive element in reinstatement.
I'm following you, my lord. So that so far as he is contending that there had been delay in the treatment of Mr. Daban, the deceased, that could not be so. The platform of the case is that this is a Section 14 application, that there is a comparator, and that his comparator has been treated differently. And there was no comparator at all between 1960 and 1980, indeed not until 1990. So that as it was presented initially, the appellant's case was that you treated me badly in 1969 and in 1980, and until 1980, by simply not treating with my application as it was then, to be re-employed. What transpired between 1980 and 1990 are that he was now in employment, he had accepted employment, and remained in that position until...
Well, we don't want to get into the detail of the case. At the moment, all we're concerned about is whether the appellant should be allowed to advance this case. I mean, do you say that you would be placed at a disadvantage if he's allowed to make the case that the delay occurred between the time of his release from prison and the time of his engagement? And if so, why?
But we would have presented the case differently.
In what way?
If we had been asked to deal with what occurred in 1990 as the sole plank of his case, we would have addressed the reasons why, and with more substance that is, the reasons why we chose to engage Mr. Hippolyte at one level and Mr. Daban at another level. Those reasons are set out in the documentation.
Yes, good.
But by then we would have been dealing with a clear case of a comparator
Yes, good.
and seeking to persuade the court
And
otherwise.
is there any particular species of evidence that might have been adduced which you failed to provide?
No, my lord, so that the disadvantage that we would suffer is not insurmountable,
No, quite.
but we would have presented the case differently.
Thank you very much. We'll rise for a few minutes to discuss this. Well, Mr. Poole, we think that you have grave difficulties in advancing the case for delay between 1969 and 1980, particularly in light of the way that the matter was dealt with at first instance and in the Court of Appeal. However, we have decided that de bene esse we will permit you to advance that case, but we would expect you to deal with it fairly concisely.
My Lord, I'm grateful, and I will obviously do that. In that case, the way I intend to structure my submissions divides in 6 parts. First, I'll emphasise some points arising from the facts. Secondly, I'll briefly, and I emphasise briefly, deal with the legal principles in play for an equal treatment claim, as the board is familiar with them, and I don't think there's anything controversial. Thirdly, I'll address the respondent's abuse argument and explain why we say this is an appropriate case for constitutional relief, and in fact, we say it's the only appropriate remedy in this case. Fourthly, address the respondent's comparator argument, why they say Mr. Hippolyte is not an appropriate comparator. Fifthly, I will, in light of the board's indication, briefly deal with the delay point, and then finally deal with what I call the permanent employee point in the printed case.
And at some point that will include a brief reference back to Webster to show us the point that you made briefly.
My lady, yes. When I'm dealing secondly with the legal principles, I'll take the board to Webster and just emphasise some points that are relevant to particularly the comparator argument that is advanced by the respondent. So dealing with the fact first, I just want to emphasise 5 points arising from the facts. First, the board will have seen from the printed cases and other cases before this board that, broadly speaking, there are 2 types of workers. There are monthly paid workers, namely those that are permanently employed, and hourly paid workers, namely those that are temporarily employed. And if I can just give the board the reference to the case of Box Hill, which is at tab 6 at page 607. I don't propose to take the board to it, but just for your lordship's and your ladyship's note, at paragraph 5 of that first instance judgment, at page 610, there is in my respectful submission, a useful exposition of types of workers and particular reference to there being workers on the rolls, namely temporary workers, there being 4 roles, a hierarchy starting with port followers, temporary role, retrenchee role, and seasonal role. And obviously in this case, we're particularly concerned with port followers and those on the temporary role. And it is common ground between the parties that there is that hierarchy. And what that means in practice is that port followers are offered any work first before those on the temporary roll. And that's explained, just for your Lordship, Ladyship note, it's page 38 in the record, which is paragraph 24 of Miss Stuart Toussaint's affidavit. Second point on the facts. Prior to his conviction in 1964, the appellant was employed as a permanent worker. Just draw attention to the fact that that was disputed at first instance, but we have findings of fact.
We don't need to worry about that.
My Lord, of course. Those findings are first instance, page 368, para 6, and in the Court of Appeal, page 468, para 3. The consequence of being a permanent worker is, as recorded by the judge at paragraph 13, page 372, permanent workers earn on average $1,500 a week more than temporary workers and are entitled to a pension and a gratuity on retirement. Third point, it is common ground that following his release from prison, the appellant presented the respondent with a letter from the prison welfare officer recommending his re-employment, and that letter is at page 270. Mr. Hippolyte presented an almost identical letter when he was released from prison, and that letter is at page 282. The respondent's case, and this, I'll deal with this briefly because it really goes to the delay point, but I observe that the respondent's case at first instance and in the Court of Appeal was that before it acted, and those are the words used by Miss Stuart Toussaint in her affidavit at paragraphs 35 and 36 at page 41. So before the respondent acted on this recommendation, the appellant had left the country and remained out of jurisdiction and unavailable for work until 1980. This point was also made by Mr. Peters, who was another person who provided an affidavit for the respondent. It's page 275, paragraph 8. And he makes it clear there that Mr. Hippolyte was re-employed because he made himself available for work, unlike, wrongly, he says, the appellant. And one final point for your note. There's a letter from the respondent to the Attorney General's office, page 252, that states, before Mr. Daban's letter could have been considered by the authority, he migrated to England. Now, we know that that case was rejected by both lower courts, and the reference for those findings, first instance, page 369, paragraph 8, and page 384, paragraph 34, where the court finds that the appellant was in the jurisdiction between 1969 and 1980, and importantly, and this goes to a point Lord Kerr raised with me earlier, a finding that he persevered in his quest to be re-employed. And in the Court of Appeal, they say there's no basis to disturb those findings made at first instance, and the reference for that is at page 478, paragraph 37. And in my submission, on the delay point, we say those findings are critical because it goes to the very heart of the justification argument, namely that there is no justification for the delay in re-employing between 1969 and 1980. There is, however, another important aspect to this that really goes to meet a point that the respondent makes, which is, to paraphrase, the respondent says, yes, but there was no policy or no practice of the respondent to re-employ people upon release from prison. And I say 2 points in response to that. I say first, well, on the evidence, it appears the practice was, in fact, absent some special feature, for example, not being available for work, absent a feature of that nature, it was the practice to re-employ upon presentation of a letter of recommendation from the prison welfare officer. And I say that because that's what happened in Mr. Hippolyte's case, and one can see a reference in the document. There's a record at page 284, a handwritten record of this decision to re-employ, and that simply records the fact that there has been a letter of recommendation and the decision has been made to re-employ Mr. Hippolyte.
But why does one swallow make a summer?
Well, Lord, I say one takes what happened in practice with Miss Stuart Toussaint's evidence in her affidavit, because she says every case is considered on a case-by-case basis, but then she explains what she means by that, and the reference is at page 41, para 37, and she effectively says, provided someone is available for work and there has been a recommendation, and rather than me trying from memory, let me get it accurately. So page 41, she says, the decision is guided by the reliability of the employee, his recommendations to be employed, his availability for work, and general principles of trust and confidence. And in my submission...
She's saying it's not a practice.
No, my Lord, but I say when one actually looks at the decision that was made in Mr. Hippolyte's case, which is, it doesn't record, for example, this man had an unblemished work history prior to him being employed. He is now available for work, and we have no doubt that trust and confidence has not been broken. All it records is there has been a recommendation from the prison welfare officer, and we will re-employ him. Now, if the respondent...
Sorry, the evidence in paragraph 37 is express that there isn't a practice. There's no policy. Everything's done on a case-by-case basis.
Well, I say yes. That's what Miss Stuart Toussaint is saying there. But I say,
and forgive me, there's no finding, is there, by either court that there was a practice?
No, my Lord. And so my first point is, I say, actually, what happened on the ground gives the lie to what is said in paragraph 37. But perhaps my better point is my second point, which is focusing on whether or not there's a practice is in fact the wrong question.
But you said there was a practice, and we're a bit worried about that particular submission.
My Lord, yes, and the basis on which I say there is a practice is looking at what happened in reality and Mr. Hippolyte. And also, perhaps just to add to that, it would appear that from what Miss Stuart Toussaint says at paragraphs 35 and 36, that, and this is my emphasis of the word, before the respondent was able to act, I say what one reads from that is that had they not believed the appellant was out of the jurisdiction, the presentation of this letter from the prison welfare officer would have led, I say, to the appellant being re-employed. That's how one reads in my submission what is being said, paragraphs 35 and 36.
If it rests solely on the experience in relation to Mr. Hippolyte, it by definition can't establish the existence of a practice or a policy. I mean, in the absence of any evidence about other applicants for employment after incarceration, how could that possibly constitute a policy or a practice?
Well, all I am able to point to, because this was the focus of the evidence,
I mean, there may have been
Mr.
hundreds of
Hippolyte's.
people who had applied before Mr. Hippolyte and had been turned down. In the absence of evidence, one way or the other, we simply don't know.
My Lord, you have my submission on the practice point, and I hear the reservations the board has. So my second and hopefully better point is whether it's a practice or not is the wrong question in a case of unequal treatment. The point is that if Mr. Hippolyte is similarly circumstanced so as to be an appropriate comparator, as both lower courts found he was, and I'll address why I say they were right in a moment, the difference in treatment has to be justified. And there is no justification in this case that withstands any proper scrutiny in my submission. So the focus is not on whether there was a practice or procedure. It is whether there has been unequal treatment, whether the sameness question is answered, and then whether there has been justification, it obviously being on the respondent, the burden being on the respondent to justify and explain the difference in treatment. My fourth point on the facts, it is common ground that when the respondent was re-employed in 1980, when the respondent re-employed the appellant in 1980, he was re-employed as a daily paid temporary worker on the temporary role. And we see that finding at paragraph 8, first instance, page 370. And for a document, at page 232, one sees the appellant's name on the temporary roll as well.
He was made a port follower later, wasn't he?
He was in 1993, my lord.
Exactly.
Fifth point, Mr. Hippolyte, prior to his imprisonment, was employed in a temporary position, but as a port follower on the port follower's roll. And we see that finding, it's paragraph 37, first instance at page 386, and the document at page 210 with his name on the port follower's roll. We say, and this goes not to the delay point, but to the permanent employee point, we say that is an important point when one looks at the Court of Appeal's reasons, because I do, with respect, say that the Court of Appeal have simply made a mistake here on the evidence, when they held that the respondent had offered the appellant the same temporary employment that was offered to Mr. Hippolyte. And that's the Court of Appeal's judgment, paragraph 42 at page 479. And I'll develop that submission when I address the permanent employee point, but I just want to flag it at this stage that we say it's an important aspect of the appellant's case, because there is a consequence to being a temporary worker as opposed to a port follower, and it follows from what I described as the hierarchy and the structure of the roles I briefly explained earlier. And so the consequence is a reduced amount of gratuity and a reduced amount of available work. And just to meet a point that the respondent makes, because I think it is said that this isn't part of the new case, the delay point, but it is said discreetly in respect of the permanent employee case that this is a different formulation how it was put before, and it's never been suggested as an alternative to permanent employment that the appellant should have been re-employed as a port follower. And I say, I recognise that that's not, when one looks at the constitutional motion, one looks at the declaratory relief sought, that's not part of the declaratory relief sought. But relevant findings have been made, and it is, in my submission, part and parcel of the attempt of justification by the respondent, and part and parcel of the Court of Appeal's mistake, because I say it follows that if the Court of Appeal, as I submit they have when dealing with the permanent employee point, have wrongly assumed that both the appellant and his comparator were given the same temporary employment, I say it follows that at the very least the appellant is entitled to re-employment as a port follower, albeit his primary case is permanent employee status.
That runs up against the difficulty about this new case. It would have been perfectly feasible for you to make the case, not for you, but for the appellant to make the case at the first instance, that by way of alternative he should have been appointed as a port follower. That then could have been addressed. But that case was not made. How can we now examine whether or not there was any justification for not appointing him as a port follower when that question hasn't been addressed by the lower courts?
My Lord, in my submission, it's addressed on the evidence and relevant findings are made, such that the board, I'm not inviting the board to conduct it obviously is not in a position to conduct a factual inquiry, and it doesn't need to resolve this point. And it is put as an alternative to our primary case on the permanent employee point. And I will address it when I address the permanent employee point, insofar as I need to say anything further about it, if I may.
Right.
Dealing then, moving away from the facts and dealing with my Lady Arden's point about Webster, we deal with the correct approach to determining equality of treatment under section 4D of the Constitution at paragraphs 14 to 20 of our printed case. And that page is 529 to 531. There is no dispute as to what the test is, and if I can ask the board to have regard to tab 18 which is page 999 of the record, which is the case of Webster. And at paragraph 10, Lady Hale, under the heading The Legal Principles, sets out section 4 of the Constitution, section 4D, the right of the individual to equality of treatment from any public authority in the exercise of any functions. Makes the point at paragraph 14 that it is unusual in terms of other constitutional provisions that this is an open-ended constitutional guarantee of equal treatment. At paragraph 19, there's the observation that sameness and justification are not rigidly discrete and they can merge into one another. And a quote from Lord Nichols in well-known case of Carson. There is then a discussion as to whether or not mala fides is required for the element. We're not concerned with that in this case. Paragraph 24 then sets out what is described as the current approach to section 4D, and this is the approach that's been adopted by the courts in Trinidad and Tobago. So namely, first, situations must be comparable, analogous, or broadly similar, but, and I emphasize, need not be identical. Any differences between them must be material to the difference in treatment. Once such broad comparability is shown for the public authority to explain and justify the difference in treatment, to be justified, the difference in treatment must have a legitimate aim, and there must be a reasonable relationship of proportionality between the means employed and the aim sought to be realized. Weighty reasons will be required to justify differences in treatment based on the personal characteristics mentioned at the outset. It is not necessary to prove mala fides on the part of the public authority. And then recognition in paragraph 25 about the overlap between the sameness question and the justification question.
But I thought you told us this morning that it also is authority for the proposition the comparator can be found later.
My lady, no, I don't know. I don't say Webster deals with that point. I say that when one is focusing firstly on whether situations must be comparable, I say there is no reason why what is being compared is, for example, a personal situation in 1969 with a personal situation in 1991, where and the way I put it is that it doesn't go to the sameness question, but it can, of course, go to the justification or explanation for any difference in treatment if the public authority sought to explain the difference in treatment by the passage of time. But I say, in principle, there's no reason why you can't compare a situation several years apart.
Well,
Yes.
My Lord's very kind. I was just going to say it struck me as difficult for the employer. I mean, as a matter of common sense, how could he have had both parties in mind in 1969?
Well, that's why I say it can come in legitimately to the justification question, because for the complainant to establish his cause of action under Section 4D, he needs to establish that there is someone that he can point to that is sufficiently similarly circumstanced, but has been treated, or he has been treated differently to that person. Once that's established, what Webster says is then the onus shifts to the employer or the public authority to justify and explain that difference in treatment. And that's where I say it would be open to a public authority to say, well, of course, Mr. Smith has been treated differently to Mr. Bloggs because we're looking at a situation in 1969, we're looking at a situation in 1991. Policies have changed, practice has changed, the staffing levels that are required at one position or another position have changed. And that's all could be.
I wonder whether that can possibly be right. Of course, it may be an element of justification, but the differential treatment doesn't begin until the later date. And therefore, there's no question of discrimination before the later date is arrived at.
My Lord, that would lead to the position where the absent justification...
Forget about justification. I mean, deal with the anterior question of whether there has been any unequal treatment. until the more beneficent treatment of the later individual occurs, there's no question of unequal treatment at all.
But, my Lord, the fact in my submission that the unequal treatment, as it were, crystallises later does not alter the fact that one can compare the situations of the two people and look whether their situations are broadly comparable.
I mean, let's take the case of an employer who in 1969 is not as enlightened or is not as benevolent as he becomes in 1980. But in 1980 he decides, well, I'm going to give this man a chance after his release from prison. Does that mean that he's cast back to all the decisions that he's made in relation to any individual before 1980, which could be categorized as less benevolent than the treatment meted out in 1980?
Well, in my submission, the answer is yes, provided that the sameness question is answered in the affirmative and that both cases are established as being broadly comparable or analogous. And then I do say...
Well, does that exercise involve looking at the circumstances in which the employer found himself at the two stages?
Well, and this perhaps goes to the point that's being made, was made by Lord Nichols in Carson and several other cases leading up to Baroness Hale's point in Webster, which is there is obviously significant overlap between the sameness question and the justification question. And it could, of course, be relevant to compare, for example, my example to Lady Arden, the sort of staffing levels or requirement for a certain number of employees in 1969 compared to 1991.
But take my Lord's example, it's just a change of attitude on the part of the employer. So there's nothing like staffing requirements or anything like that that can be pointed to. In 1969 or whatever, they didn't think it was a good idea to re-employ such persons. In 1980 or 1989, they did.
Well, my Lord, the answer to that is it is relevant, and if it's just a change in attitude, that goes to the explanation and justification for the difference in treatment, the onus being on the respondent, and then one has to look at, as we're told in Webster, whether that justification is legitimate and a proportionate means of achieving its aim. And so one would then have to analyse why has there been this change in attitude?
To which the answer on the example given is simply, we thought it was a good idea at one, or not a good idea at one point in the past. We now think it's a good idea. That's all there is by way of justification.
My Lord, well, that wouldn't, in my submission, if they were the facts, that wouldn't be a reasonable, legitimate justification. And the claim for equal...
It brings about a most incongruous situation because that would operate as an inhibition on the part of an employer to adopt a more enlightened approach later, lest he be saddled with claims for discrimination that would go back historically in a limitless sense. I mean, that seems remarkable.
Well, with respect, I say no, because in those circumstances, if you're moving towards a more enlightened approach, then you would be able to justify your change in attitude.
Yes, but you'd leave yourself liable to claims for discrimination because it was discovered that you treated someone 20, 30, 40 years hence in a more enlightened way.
My Lord, I say, again, with respect, no, because...
and you'd have to justify it. You'd have to...
You would be able to justify. Yes, you might be met with...
But, sorry, I thought you just told us that you couldn't justify it. If all there is a change of view, becoming more benevolent in my Lord's example, I thought when I asked you before, you said, well, that wouldn't be justification.
My Lord, sorry, in answer to your Lordship question, if it was simply, I think it was put to me on the basis, if it was just simply a change of view and the employer saying, I've just changed my view, my answer to that is, obviously that's not enough.
Than I was
well, if the answer, if it goes further than that and the employer says, well, I've become more benevolent now because, and explains gives a rational justification for why they've become more benevolent, whether it's just changing norms in society, becoming more alive to issues such as raised by these type of cases, then that may well go to meet the justification question.
Well, Mr. Poole, I'm sorry, after you.
No, you do continue.
Mr. Poole, developing the concerns of my lords and applying them to the actual facts of this case, we have this submission from you. Had this case come before the courts of Trinidad and Tobago in 1989, your claim for discrimination would have failed. But after 1991, it succeeds, and it succeeds not in relation to the period from 1991, but from 1980, or as you would say, from 1969. That's odd, isn't it?
My Lord, I say it's not odd because the point of comparison only arises in 1991, and if that gives rise to a legitimate complaint of unequal treatment under the Constitution, then it's important that constitutional rights are vindicated.
Have we got any assistance from the lower courts on this point?
My Lord, the short answer is no, because both the lower court and the Court of Appeal found that Mr. Hippolyte was an appropriate comparator. And I'll take you when I deal with the...
Well, you've been shipping quite a bit of fire, especially from me, Mr. Poole, and I don't want to be unkind, but I don't think necessarily this is your strongest point, so you might move on from it.
My Lord, I've dealt now with the legal principles for equality of treatment, and next I was going to deal with the abuse argument. So this is a point that's raised by the respondent. It's a point that was run in both the first instance and in the Court of Appeal, and both lower courts dismissed the abuse argument. The abuse argument that was run had two limbs effectively to it. First, this was, I think the way it is put is the challenge falls within the realm of private law rather than public law, is how it's put by my learned friends in their printed case at paragraph 18 at page 544. There was another limb to it below, which was that there was an alternative remedy. The alternative remedy argument is not advanced. I say actually that's an important, whether it's a concession or not, but it's important because it rather recognises the findings that were made below that there is no alternative remedy for the appellant, it being suggested that he had a remedy under with the industrial courts. Yes. So there is no alternative remedy, which rather feeds into why we say that this is a paradigm case in my submission for constitutional relief under section 14.
And there's no limitation period which cuts off constitutional claims. Is that right, Mr.
My Lord, that is right. That is right, although I say that you've got cases that I can give you the references for that, although there is no statutory time limit, the lapse of time since the events in question is a relevant factor in the exercise of the court's discretion. But and this is a point, in fact, that was made by Lady Hale in Webster, paragraph 46 at page 1012. And having made that observation, she does go on to say that the court should, however, be reluctant to shut out an applicant on the ground of mere delay. But just for your note on this point, there's a case called Durity, which is a judgment with Lord Nichols, tab 10, page 820. And the question that was posed, very briefly, if I just turn it up to give you the references, the question is posed at paragraph 35 on this delay question. Lord Nichols says, in this context, the board considers it may be helpful if they make some certain general observations when a court is exercising its jurisdiction under section 14 and has to consider whether there would be delay, such as would render the proceedings an abuse. It will usually be important to consider whether the imputed decision or conduct was susceptible of adequate redress by a timely application to the court under its ordinary non-constitutional jurisdiction. In my submission, the answer to that question that's posed there is no. In this case, and both lower courts dismissed the alternative argument, and their findings, first instance, paragraph 26, page 381, and in the Court of Appeal, paragraph 25, page 474. I do, though, go further, if it be said, and it may be that this is a point really for reply, to see whether this point is pressed at all, and if so, how hard by the respondent. Because I do say, leaving aside the no alternative remedy point, I say there has been no culpable delay on the part of the appellant in this case. But perhaps having put down that marker, if it's taken against me, there has, perhaps I'll deal with that in reply insofar as I need to. Returning then to the abuse argument, we deal with this in our supplemental printed case. It's at pages 553 to 556. And we divide those submissions up into addressing first the question whether the Port Authority is a public authority, and second, whether it's exercising public functions. And we say...
but isn't it this dispute that it is a public authority, is there?
My Lord, no. And therefore I will deal with that briefly. But the reason we flag it is we say the analysis of how one arrives at the position of whether or not it is a public authority feeds into the analysis of whether it's, if I can call it, a public function question. So just dealing with the public authority by way of perhaps just giving some references. The Box Hill case, which I've briefly taken you to already at tab 6, that's the first instance decision. The Court of Appeal decision in Box Hill appears at tab 7. The first instance decision was described by Lord Walker in the Carmel Smith case as an impressive judgment, and it's a judgment of acting Justice of Abu, and his finding was that the respondent, namely the Port Authority, is a public authority amenable to public law relief. And without going through that, if I can just give the board references to that judgment. Paragraph 16, at page 615, focuses on the wording of section 4D, namely unequal treatment by a public authority in the exercise of any function, is the wording. Paragraph 19, at page 616, the point there is made that the courts take a broad view of what constitutes a public authority. The well-known cases of Foster and Aston Cantlow are then cited, and then at paragraphs 25 and 26, the learned judge draws a distinction between Human Rights Act cases and constitutional cases in Trinidad, making the point that the Human Rights Act distinguishes between those that are entitled that have the functions of a public nature and entities that do not, and that distinction is not a distinction that is made in the Constitution. And then the judge finds at paragraph 26 that the Port Authority has the insignia, in his words, of a core public authority. And notes in particular, and there are hard copies that can be handed up, I don't think there isn't an issue, that the Statutory Authorities Commission in Trinidad delegated specific statutory powers to appoint, promote and discipline to the Port Authority. And perhaps, if just so the board have it, there's the Statutory Authorities Delegation of Powers Order, which is the smaller, yes, that one there, great. That could be handed up. As I say, there's no issue, but just so that the board has it. This is the the order that delegates those powers of appointment to the respondent. And then the Court of Appeal in Box Hill, which is at tab 7, at page 659, agreed with Mr. Justice Abu on both aspects and held the test as laid down in Foster was the appropriate test to be applied. And the Court of Appeal concluded that the respondent met all of the Foster criteria, and we deal with that at paragraph 8 of our printed supplemental case at page 555, And we say, perhaps unsurprisingly, the Court of Appeal in this case the Court of Appeal in Box Hill were plainly right to find that the Port Authority was a public authority. Dealing then with the public functions question.
Can you just help me?
My Lord.
Why does public functions arise as a separate question? I mean, Section 4D talks about equality of treatment from any public authority in the exercise of any function.
My Lord, we say, and our primary case is, it doesn't, in the sense that one can read Section 4D, that once you've established that this is a public authority, then any functions. The difficulty I have with that submission is in the Court of Appeal in Box Hill and in first instance and Court of Appeal in this case, it was accepted that there will be some functions carried out by public authorities that are not of a public nature and could not be the subject of constitutional challenge. And so I as it were, I sort of live...
When you say accepted, do you mean ruled?
Yes, my Lord, yes. There were findings in the Court of Appeal in Box Hill. That's at paragraph 51 at page 681. And in the present case, both when dealing with this abuse argument of first instance and the Court of Appeal. The answer, though, in my submission is a short one. The challenge in the present case, as in Box Hill, is that the appellant has been treated unequally contrary to Section 4D of the Constitution, and that clearly attracts the sanction of the Constitution. And it is Section 4D itself that provides the basis of the complaint. And in my submission, this alone is a sufficient basis upon which the appellant can proceed. And that was the, although put more eloquently than I've just put it, that was the ratio of the Court of Appeal in Box Hill, which is the reference I just gave my Lord Sales, the paragraph 51 at page 637. And it's the passage that we set out in full, including the next paragraph, paragraph 52, in our supplemental case at page 556. In particular, we draw attention to paragraph 51 in the Court of Appeal. Any act of discrimination will attract the sanction of the Constitution. No pattern of discrimination is required. A single act will suffice. Provisions of Section 4 themselves provide the basis of the complaint. They found the claim. That is a sufficient basis upon which the claim can proceed. So we say, in short, both courts below were right to reject the abuse argument, and we invite the board to reject the abuse argument. Dealing next with what I've called the comparator argument. Now, this is another point that's being advanced by the respondent against, I submit, in this case, concurrent findings of the courts below, namely whether or not Mr. Hippolyte was an appropriate comparator or not. And we make two main points in response to this. First, the point I've just flagged, which is that both lower courts held that the appellant and Mr. Hippolyte were similarly circumstanced. And the relevant findings there are, first instance, paragraph 36, page 385, and in the Court of Appeal, paragraph 34, page 476. We say in those circumstances the respondent faces a heavy onus to displace those concurrent findings, and we refer in our printed case to the well-known principles in cases such as Devoy and Roy, which is at tab 9, and Central Bank of Ecuador, which is at tab 8. I don't say that they are pure findings of fact. They are evaluations of facts. But nevertheless, I submit they are evaluations of facts that, given, in my submission, both lower courts applied the correct legal principles, they are evaluations of facts that should weigh heavily against the respondent's challenge to the comparator point.
Might it not be said that there are two ways of analysing the situations of Mr. Hippolyte and the appellant? One is just they were employed by the Port Authority. Mr. Hippolyte was re-employed, the appellant wasn't. And so you look at them simply as employees, one being employed, one re-employed, one not. but then the question of the permanent employment status of the appellant doesn't come into the analysis if you look at it that way. If you try and build into the categorization of the situation the permanent employee status of the appellant, so that he is someone who was a permanent employee and isn't taken back as a permanent employee. Mr. Hippolyte wasn't a permanent employee, it was not taken back as a permanent employee, then might it not be said that they don't, if you look at it in that way, they don't look comparable?
My Lord, it can be said in that way, and in my submission this goes to the point that's made by Baroness Hell in Webster, which is that there is a considerable overlap between the sameness question and the justification question. I say, and our primary case is the correct way to look at it is how the lower courts looked at it, which is looking at the fact that both men were previously employed by the respondent, both served custodial sentences, both were promptly presented themselves for re-employment, both had letters of recommendation from the prison welfare officer, and both were in fact re-employed, leaving aside the delay point. And I say, on a proper analysis of applying Webster to those facts, acknowledging that the situations don't need to be identical but broadly similar, I say the test is met. But I take my Lord Sales's point.
I mean, it might be said, if you categorise it in that way, don't you face the difficulty, but then they're treated the same, because they're just, if you're just looking at it in terms of re-employment, in 1980 he was re-employed, as Mr. Hippolyte was re-employed, I think, in 1990.
My Lord, yes, and that's why I say that the sameness question is answered in the affirmative, but the correct place for the point you put to me, which is looking at their status, goes to the justification question. And I say
but I think that's why I'm pressing you on.
Yes. Oh, yes.
Is it right to say it just goes to justification? Because if you want to build into the comparability analysis that what being taken back by the employer meant was taken back at the same status as you had before, you then, might it not be said, are building in a factor which renders them both not in a comparable situation.
Well, the straight answer to that question is, I say, it does just, the sameness question is discrete, and what my Lord Sales puts to me, that goes to the justification question. And this is the point we make at paragraph 22C of our printed case, page 532. And the reason I say that, I say it's not such, the difference in status is not such an obvious and relevant difference, such that the situation should not be regarded as broadly similar. And it really goes to when the respondent should be called on to justify. And I say that this is a case where the respondent should be called on to justify the difference in treatment. But we recognise that the difference in status is relevant because it comes in at the justification. And it may be that it is a distinction without any real meaning, which is the point that observed in Webster, which is the sameness and justification question are inextricably linked and sometimes overlap, and it's a point made in the case of Carson. But we do say, first, both lower courts were right to find that these were broadly comparable and to then move on to the justification question.
There does seem to be a modern tendency, I think, Mr. Poole, I don't know whether that's your experience, of jumping through the initial hoops quite promptly on the basis, oh, let's get on with justification.
Well, one can see perhaps the policy reasons behind if you can establish broad comparability requiring an explanation and justification from the public authority.
At the time,
sorry, my lady.
Did you finish the sentence? I'm sorry.
Yes.
Yes. By the time they came to apply, and taking my Lord Sales' list of points, and they present their letters of recommendation, at that point, neither is an employee, each is a former employee.
Yes.
And in fact, they have no rights under the previous contract of employment left over.
No, my lady.
So that's another feature of their being in the same position, is it not?
Well, my lady, that is of course right. I mean, leaving aside what was argued about reinstatement, which doesn't concern the board,
No.
I respectfully agree that
I think
the
problem
period
with that
of
is
custody.
You have to have a comparator who's been treated better than you in order to advance your claim, don't you?
Well, I think you would want a comparator
you're
that's
the
been treated
same.
better than you.
You're both the same, Mr. Hippolyte, and you when you're both applying, but there hasn't been any advantageous treatment afforded to him until he's appointed.
Well, no, that is
So
right.
it's after his appointment that the comparison has to be made. Anyway, we probably have exhausted that topic as well.
Well, my Lord, unfortunately not, but I will very briefly, just because there are 3 points made by the respondent, which are dealt with in the printed case, but I just want to give you really the highlights of what we say about them. Because first it's said that, by the respondent, it is said, the courts below wrongly held that Mr. Hippolyte's re-employment amounted to reinstatement. They say that paragraphs 25 and 28 of their printed case. They second make the point, if I can call it my Lord Sales's point, or rather question to me, because it said that the fact that Mr. Hippolyte was a temporary worker rather than a permanent worker prior to imprisonment meant that there was not broad comparability. And third, they say that the fact the union did not object to Mr. Hippolyte's reinstatement was a material difference. And so just dealing with those 3 points and giving the board my answer to them. The first point, very quickly, I say the respondent's in fact wrong to accuse the lower courts of making such a finding. Both lower courts, in fact, correctly held that both men were re-employed with the effect that time spent working prior to the time in prison was forfeited. And the findings there, first instance, it's paragraph 37, page 386.
Can we just understand what you mean by forfeited?
So,
both had been, particularly your client, he'd been a permanent member of the working force.
yes.
And he'd been accumulating years, and you'd have thought in principle that would go to pension and gratuity. When you say it's all forfeited, is that all scrubbed for some reason, Mr. Poole?
Yes.
Why would that be?
Because it really goes to my Lady Arden's point, which is that when there has been their employment is terminated with effect from them leaving to serve their custodial sentences,
yes.
And then they're re-employed 1980 and 1991. They're re-employed with effectively a clean slate. It being argued below, and this is the point you put earlier, my Lord, about the needing to be clear when one talks about reinstatement and re-employment.
Why?
Because it was argued that, in fact, the appellant should be reinstated. So the effect of that being that his years of service since 1960 should count for such things as pension rights and gratuity. But both first instance judge and Court of Appeal found that, in fact, both men were re-employed, and the words they used were that the time spent working prior to their imprisonment was forfeited. So effectively, they start accruing, for example, continuous years of employment for the purposes of pension as of my client 1980, as of Mr. Hippolyte 1991.
But they were both in the same position.
Yes.
And they would be in the same position, would they, of somebody who decided to take a sabbatical for 5 years?
Yes, the reason I pause is it would depend. I think someone taking a sabbatical would probably try and negotiate with their employer, but leave aside that, yes.
Because the qualification was continuous employment.
Yes. So that's the first point. I say there hasn't been the finding that the respondents rely on. The second point, which is Lord Sale's point, I've really dealt with. It's dealt with at paragraph 22C of our printed case. We say that the difference between being a temporary employee and a permanent employee, that goes to justification rather than sameness. The third point is quite an important point, and if I deal with it now, it will probably cut down the time I need to develop the permanent employee submissions, because this is the argument that the union did not object to Mr. Hippolyte's reinstatement. And so the respondent seeks to distinguish between Mr. Hippolyte and the appellant on that basis, and they do that. This is paragraphs 30 to 31 of their printed case. But they do that relying on page a handwritten note that appears at page 281 of the record. It's quite difficult to read, but this really is the extent of the evidence that was before the courts on this question, and it's a letter of the 13th of May 1991 referring to Mr. Hippolyte, and then the handwritten manuscript note says, I think, Labour officer, the matter was discussed with the, don't know, they have no, union, of course, union, with the union. They have no objection to the employee being reinstated as a consequence. I'm grateful approval has been given for his reinstatement. And the respondent contrasts that with the letter which you see at page 26 of the record, which I say is a sort of, if you like, after the event justification by the respondent, but it's a letter dated 22nd of November 1996. And it's the second paragraph. So they make the bad point again about him being out of the country, but then they go on to say, he was offered re-employment as a temporary worker in 1980, which he accepted. To reinstate at this time would automatically make him senior to all port followers who have been employed from as early as 1971, which would not be accepted by the union. So they say that that's a relevant point of distinction between the two men. Now, the Court of Appeal rejected that argument, and the Court of Appeal's judgment rejecting that is at paragraph 38, page 478. And for the reasons at paragraph 13 of our printed case, which is at page 529, we say the Court of Appeal plainly right to reject that argument for three reasons. And if I just briefly outline what they are, we say first, the decision whether or not to re-employ or to employ and or re-employ someone is ultimately the respondent's decision. It cannot abdicate its responsibility even when acting on the advice or consultation with the union. And that's a point that was made in Box Hill, and the reference for that is paragraph 33 at page 628. Second, we say the union's position on reinstatement played no part in the respondent's decision not to re-employ the appellant between 1969 and 1980. That obviously goes to the delay point rather than the permanent employee point. But third and finally, we say the logic of the union's position does not explain or justify the decision to re-employ the appellant as a temporary as opposed to a permanent worker. So this goes squarely to the permanent employee point. That's because re-employment does not raise the same issue concerning seniority that reinstatement raises. So the objection to the appellant's reinstatement as expressed in that 22nd of November letter, by reinstating he would be senior to all other port followers, and that's unacceptable. Those concerns don't arise with the question of re-employment.
Yeah. He then gets guaranteed work, which the port follower doesn't.
But, my lady, that's not the concern that's being expressed, but the concern being expressed by the union is seniority. There is, of course, the difference between a permanent employee and a temporary employee, one being guaranteed work, one not being. But that's not the justification that is advanced. The justification that's advanced is that the union would effectively not agree to reinstatement because of the issues raised of seniority and putting him above other people as a consequence of counting his previous years of employment. And I say that meets, or arguably that meets, the Court of Appeal found it didn't, but it goes to the question of reinstatement.
I thought that the whole nub of this case, and the Court of Appeal's decision, was that if you're a temporary worker or a port follower, then you're down the pecking order, and if there's not enough work, if all the work for the day is mopped up by the permanent workers, I'm afraid you go home without work. And I thought that the whole gravamen of this case is, look, you're saying you should have been reinstated as a permanent worker. You'd have then jumped over all the people on the port followers list, and it's not fair. You did something terribly wrong, you went to prison, you now come back, and you say you should jump over in terms of availability of work from day to day, all those people on the list who've been working and pursuing a blameless life for 20 years. That's the case against you, isn't it?
My Lord, on this point, no. That is what, and this is what I come to, when I come to the permanent employee point, I say that what the Court of Appeal effectively did was, with the greatest respect to them, to make up their own justification arguments, because they were not the justification arguments that were put forward by the respondent.
That's the one they based it on.
My Lord, and I will...
Speaking entirely for myself, I do hope, and I know, knowing you, you're going to deal with it probably very effectively, Mr. Poole.
Well, my Lord, I don't know about the latter, but I will certainly deal with it. But what I'm trying to deal with at this point is a discrete point that was made on justification by the respondent, and it was really, and this was the heart of the justification argument, which is the union would not have supported, and this is how it was put in the Court of Appeal, and the Court of Appeal rejected that argument, but then went on to make their own findings about justification. And what was said is the union wouldn't support it because of the question about seniority, and I say, well, that doesn't arise on the re-employment case. That's the short
Thank
point.
But when Mr. Daban was first employed, he was employed as a temporary worker. He only subsequently graduated to being permanent, which would suggest the port didn't regularly, might not regularly employ people on a permanent basis first off.
Yes, I take your ladyship's point, because you were certainly right on the evidence that I think the evidence was for about 1 or 2 years before he was made a permanent employee. He was a temporary worker. Moving into the delay point, and with Lord Kerr and the board's words sort of ringing in my ears that I should deal with this fairly swiftly, I will endeavour to do so. It is a short point anyway, because we say there is no justification for the period 1969 to 1980 for not re-employing the appellant. And there are unchallenged findings below to that effect. I think the board has really heard my submissions on why we say this isn't a new case already, and why, if it is, we should be permitted to pursue it. I earlier identified where in the evidence we point to as showing that the delay point was sufficiently put in issue in the courts below, such that it is fair for the appellant to now run at this point before the board. What I didn't go on to identify are where in the judgments we say relevant findings are made. The judgment of first instance, you have the judge's analysis of the delay argument at paragraph 36 at page 385. And for the time being, I don't intend, unless the board wishes me to go into the record, I will just give the references for the time being. Then the judge's conclusion at paragraph 39, page 387. And this is the discussion I had with my Lord Sales. I say there are two discrete findings made, only one of which, for no good reason in my submission, is effectively converted into a declaration. But you have first the finding of unequal treatment in delaying the re-employment, which relates to the delay 1969 to 1980, and then a finding of unequal treatment in not re-employing in the position that he formerly held. So there you have, in my submission, the delay point and the permanent employee point. The Court of Appeal, as I've already made the submission, understood the delay point was part of the claim. They identify that they are dealing with two distinctions in treatment, and that reference for that is paragraph 33 of their judgment at page 476. They say the first distinction in treatment is the time that elapsed between release from prison and re-employment, and the second distinction is between the position the appellant and his comparator were given upon re-employment. So they understood the delay point and the permanent employee point. And I say...
well, as a point of distinction, not as a point of grounding relief.
My Lord, they do go on, rather than just identifying it and then, as it were, putting it to one side and not saying any more about it, they go on to address the evidence on delay and find that there is no justification for the delay. So I say yes, it is an unsatisfactory position, but the position one finds oneself in is that there is sort of rather floating not tied down to any relief, a unjustified, unequal treatment as a consequence of the appellant not being re-employed between 1969 and 1980. If I'm wrong, and this is to be characterised as a new claim, I submit shouldn't matter because there's no new factual inquiry required. Relevant findings have been made, and really the only prejudice that's identified by the respondent goes to the question of compensation, because I can readily see that if this goes to an assessment of damages before the master, before a judge, there is going to have to be a calculation done of what, in fact, the appellant earned between 1969 and 1980 in his casual work, because he took on casual work whilst trying to still pursue his employment with the Port Authority. So one needs to calculate what that was, what he would have earned had he been employed either as a permanent employee or a port follower, or indeed as a temporary worker, depending on what findings the board might make on that. But all of those, they're not issues for the board, they're not issues for today. They're issues that will need to be determined if this matter goes to an assessment of damages hearing. But that's really what the respondents point to when asked, well, is there any evidence that one would want to lead on this question of delay? And it goes to damages rather than liability in my submission.
But you do accept that your new declarations re-delay are a matter of discretion?
Of course, my lord, I do. And I go back to the point I made in opening, that I say it would be grossly unjust for the unequal treatment that was meted out to the appellant to go unremedied and unvindicated. And what my Lord Kerr said in the case of James and the Attorney General, which is in the authorities bundle at tab 16, paragraph 24, page 936, my Lord Kerr said, the constitutional element adds an extra ingredient. Violated rights require emphatic vindication. And I say this would be a case that requires vindication and remedy. Moving then to the permanent employee point. We make our submissions on this point at paragraphs 26 to 33 of our printed case, page 534 to 536. The arguments really boil down to two main points in my submission. First relates to what I call the Court of Appeal's error in finding that the appellant and Mr. Hippolyte were offered the same temporary re-employment. And second, I say, it is the Court of Appeal's failure to properly address the justification argument. And dealing then first with the error, we set out what we say the error is at paragraph 26 of our printed case at page 534. It is essentially that the Court of Appeal wrongly thought that both the appellant and Mr. Hippolyte had been re-employed as temporary workers on the temporary role, whereas we know that Mr. Hippolyte was re-employed on the port follower's role, which was the position he held prior to his imprisonment. And perhaps this goes to the point Lady Arden put to me, which is it might be said that there is a practice that once you, if there's a termination of your employment and you're re-employed, you might start at the bottom rung of the ladder and have to work your way up. Well, that's not what happened to Mr. Hippolyte. He started as a port follower. It might be said that the bottom rung of the ladder was a temporary worker on the temporary role. That wasn't the case for him, although it does appear to have been the case for the appellant. And in my submission, following through the Court of Appeal's logic, if the board's not with me on my permanent employee primary case, say at the very least the appellant should have been re-employed at an equivalent status of Mr. Hippolyte, namely on the port follower's role, rather than, if you're not with me, on a permanent position.
But somewhere it said that it didn't make any financial difference to him because he actually got given the work as if he had been.
My lady, he says in his own affidavit, in his second affidavit, that he was, I think he puts it like this, he was never turned away for lack of work. I say that goes to, if you like, the salary element, but there is a consequence of being a temporary worker as opposed to a port follower, and that is the gratuity that is payable when you finally leave employment. And I say that is the important consequence in this case. But again, I say that is, lest it be said against me, well, where's the evidence of that? There is evidence. There is evidence that the gratuity that my client would have received a pension of 300,000 Trinidadian dollars upon retirement had he been a permanent employee, and he says a gratuity as well. But these are issues that would need to be, and I readily accept, would need to be investigated at an assessment of damages hearing. It's not a matter for the board. The point for the board, in my respectful submission to have regard to, is the fact that this isn't a meaningless exercise comparing a port follower with a temporary worker. There is a consequence, and it's the gratuity. Dealing still on this port follower point, because it is said against me at paragraph 33 of Malone & Friends printed notes, well, this isn't the way the case was put below, and I think I've given the board a taster of my answer to that, which is, it is not. I don't point to specific relief in the constitutional motion, but I submit it is addressed in the respondent's evidence, and the reference for that is Miss Stuart Toussaint's affidavit, paragraph 58, page 47. It is put as an alternative to the appellant's primary case, and I submit it is a logical consequence of what the Court of Appeal, the effect of the Court of Appeal's judgment, and their, in my respectful submission, the error that they inadvertently appear to have made. And I do say there is no prejudice to the respondent of the case being put in this way before the board. The respondents have been aware throughout these proceedings that if the appellant surmounts the sameness obstacle, the onus shifts to them to justify the difference in treatment between the appellant and Mr. Hippolyte. That, I say, is the natural consequence of that is that they would be called on to justify why Mr. Hippolyte has been appointed as a port follower and the appellant has been appointed as a temporary worker. Now, they chose in the way they presented their evidence not to address that distinction, but that's a matter for them. I say they can't now identify that as prejudice because that has always been an issue that they needed to address.
Where is the evidence that the gratuity was less? Because that's the only difference between these two categories of temporary worker, isn't it, with which we're concerned?
My lady, yes, it is.
So where's the evidence that that was different? Because you're saying the Court of Appeal made an error because it didn't pick that up. Where do we find the evidence on it?
Maybe the reason I hesitate is because I just want to check, and perhaps this is a point that I can give your ladyship if there is a reference, the reference when I make my reply. But because I think the answer may be that there's no express reference in the record to the gratuity being less between a temporary worker and a port follower.
Come back to it then.
And so I just want to double check because I agree with your ladyship that if that is the consequence that I rely on, that's the point that the board needs to take into account. The second aspect of the permanent employee point then is the lack of justification. And as we say at paragraph 29 of our printed case at page 535, it follows from what was set out in Webster that having established broad comparability, the respondent is then called on to explain and justify that difference in treatment. And in my submission, the respondent put forward no evidence for justifying re-employing the appellant as a temporary worker as opposed to a permanent worker. Now, Lord Wilson's point is that the Court of Appeal, that is the heart of their sort of finding on that. But my first point is that is not wasn't the respondent's case, that wasn't the respondent's evidence. And I do say in a equal treatment case under section 4D, it isn't for the Court of Appeal to, as it were, come up with its own justification. it is for the respondent to justify, and that is because the justification has to be legitimate and has to be a proportionate way of achieving an aim. So I take my Lord Wilson's point, which is the respondent could have sought to identify a practice whereby those whose employment has been terminated as a result of serving a custodial sentence or for some other reason, it would be appropriate for them to be re-employed at the bottom rung of the ladder, not to, as it were, jump ahead of anyone else, and then work their way back up to the position they previously held. That could have been a legitimate point for the respondent to take. That's not what the respondent sought to do. And had they done so, they couldn't have simply asserted that. They would have had to justify that and explain why there's a legitimate aim behind such a practice or such a policy. And in the absence of that evidence, I say the Court of Appeal was wrong to find justification in this case. And when one actually looks at the Court of Appeal's justification analysis, what they do, and this is at page 536, paragraph 32, they focus on the discretionary nature of the decision to re-employ someone. And I say that's really where they fell into error and they never recover from, because that is the wrong starting point and the wrong focus in a claim for unequal treatment under section 4D.
What was the reference you gave?
So I gave you, hopefully a right reference, paragraph 32 at 5.3. Oh, sorry, my lord, it's my fault, it's a wrong reference. I'm giving you the reference to our printed case. So our printed case, paragraph 32, 536, where I make the point that the Court of Appeal fell into error, but I'll give your lordship the actual Court of Appeal paragraph. It is paragraph 41, page 479, and paragraph 42, and the conclusion at 43, where they are dealing in my submission and focusing on the problems with this being a sort of discretionary power, namely whether or not to re-employ someone. And I say, with respect, that's the wrong analysis. What one has to do in an unequal treatment case is, having established broad comparability, as they found was the case here, they then look at how the respondent seeks to justify that. There is no justification for the reasons I've given. That leads, or should have led in my submission, to the appeal being dismissed.
But it's based on saying there was no difference in treatment, and therefore there's nothing to justify.
No, and that's why I come back to my first point, which is the error, because they clearly fell into error there, saying there's no difference in outcome on the basis of their finding that their wrong finding in my submission of both men being employed as temporary workers, whereas in fact we know Mr. Hippolyte was employed as a port follower.
But if you were wrong on the first point, this analysis is one they were entitled to make, surely, because they're saying, as a matter of law, it's not a difference in treatment, and therefore there's nothing really to justify.
Well, if that is what they're saying, it's difficult to square with their finding on broad comparability, because that really is then, in my submission, not applying correctly the principles that were laid out in Webster. And it goes to what I described as a sound policy consideration, which is when you've established broad comparability, the onus then shifts, in my submission, for good reason, to the respondent to justify. And so...
Well, whether it's sustainable or not, my lady is surely right in the proper interpretation of the Court of Appeal's judgment. It's not dealing with justification. And if you look at the opening sentence in paragraph 42, decision to re-employ them had a different substantive effect for each worker. That difference is one of outcome, not treatment. So they're addressing the anterior question, whether, notwithstanding the circumstance that they are in similar circumstances, Mr. Hippolyte and the appellant were not treated differently. As it happens, the outcome for them was different, but that wasn't the consequence of difference in treatment.
My Lord, you you have my submissions, which is that they at paragraph 34, have agreed with the findings below that there is broad comparability. I say, having done so, what they should properly be doing is looking for justification. In the absence of justification.
Yes, but I mean, there are stages. You've got to have a comparator, then you've got to show difference of treatment, then you've got to move to justification. They have answered the first stage, yes, these are comparators, but when they come to the second stage, they say there isn't a difference in treatment. Now, whether that's right or not is another question. But on their analysis, you don't move to the third stage because the difference, they say, is one of outcome rather than treatment. Anyway, that's probably as far as we can take it.
Well, my Lord, I hear what your Lord said. I say sort of splitting, your Lordship, is in effect splitting the broad comparability question into two discrete parts, which is not what the board suggested in Webster.
It's not my theory.
No.
It seems to be the conclusion that one reaches from a proper understanding of what the Court of Appeal is saying. Whether they're right or not is a different question.
Well, my Lord, so you have squarely what I say. I say that the Court of Appeal was wrong, because when you're dealing with whether or not there was a material difference in treatment, that is a question of justification. And I take that from what is said by Lady Hale at paragraph 24 of Webster. Once you've established broad comparability, it is for the public authority to explain and justify the difference in treatment.
The difference in treatment.
Yeah,
that's the point. You have to have three things. You have to have somebody else in a comparative situation, so a comparable situation. Then you have to have difference of treatment. Then you have to justify it.
Well, Lady, as I say, I say there is a clear difference in treatment, and you have that. That's the temporary, permanent employee point.
That's temporary
and
status.
And you've heard my submissions on the point I make about the onus being on the respondent and there being no evidence of justification. And so I do say the Court of Appeal fell into error for those reasons. And and I'll come back obviously on any points in reply, but for the time being, unless there's any further assistance I can give, they're my submissions.
Thank you. Now, Mr. Prescott.
My Lord, I do wish to start on the comparability.
Right. Start where you wish.
And to see that the Court of Appeal was right to find that in so far as the appellant and Hippolyte were comparators, they were treated similarly, in that they were both employed as temporary workers when they returned to work. This is to be found at paragraph 39 of the judgment of the Court of Appeal at page 478.
Yes.
It is clear from all sides that as the date of their application for re-employment, they had both been, their prior services had been terminated, so that they were coming with a clean slate for the potential employer. The Court of Appeal quite properly observed that having determined that they should offer them temporary employment, what the Port thought had set out to do was to try to facilitate them, to see where they could fit amongst the ranks of the temporary workers. Temporary workers, as my lords would have seen, have been identified in 4 categories. Port followers, longshoremen, a group called temporary workers, and the 4th group which I have shortly, the seasonal. Port followers, retrenchees, temporaries, and seasonal. In that order. Port followers, temporary workers, retrenched workers, and seasonal workers. They are all temporary workers. So one is a small t, the category of worker. This may be found in the affidavit of Elva Toussaint at page 38 of the record. And there's a further reference to it, my lords, in Article 3 of the collective agreement, which is an exhibit to her affidavit. And that is at 47, I think. If you just bear with me, page 57. You see Article 3 set out there. There are two categories of workers referred to: the registered workers and the workers of the roll. Those four categories which I have identified for you and to which Ms. Toussaint refers in her affidavit at paragraph 1, to which I referred you. It is clear that they are to be treated as temporary if you are in the rolls and if you're not. So that when Messrs. Hippolyte and the appellant presented themselves, the Port Authority chose not to treat them as registered workers and sought to find a fit for them amongst the temporary workers, those who could fit into any of the four groups. The Court of Appeal, pardon me, the Port Authority, the respondent here has said, we could not find a fit for Mr. Daban in 1969 into the place where he was prior to his incarceration. We are able to treat him as a temporary worker. He was previously a permanent. And in order to treat him, we are wary of impact on the seniority of others. So they placed him amongst the temporary workers in what is called the temporary role, capital T. Offered him the opportunity, therefore, of being called forward for work on a daily basis and being amongst the first in his second-tier category, capital T, temporary workers. When all the port followers had been absorbed or provided with work, he would then get work. My lords would know that the respondent himself conceded that he was never disadvantaged. He was never disadvantaged during his service from 1969 to 1980 as a temporary worker, in that he found work every day, beg your pardon? 259. He found work every day, thank you very much. Still not being here? Yes, if you look at page 259 of the record, paragraph 7 of the affidavit of the respondent, he says there, without equivocation, that he had been employed continuously from the time he came back on, and he had not been turned away by the respondent because of the unavailability of work, or on the ground that he had not the required skill, qualification, or any other.
I think Mr. Poole has accepted that, and he's already referred us to that.
Indeed. So that, my lord, I am on this point in order to demonstrate that there was no difference in treatment of the two men when they presented themselves. Assuming for the moment that they could properly be treated as comparators, which we say they could not, as at 1990, when Mr. Hippolyte returned. The shifting of the goalposts, if I may use that term, by the appellant, when he sought 3 different forms of relief, throws into great perspective how he saw his case. When the case was first filed, the relief sought, and I will read them to your lordships, although I'm quite certain that your lordships remember them, are to be found at page 5 of the record, and 1016 of the supplemental record. Right? Supplemental? Yes. May I use the language in the supplemental record at page 1016. In the first place, he sought an order that he be treated as a registered worker, which would have been his pre-1964 position. That is the order sought at B on that page.
Yes.
And then in C, he sought a declaration premised on neglect and failure or refusal to reinstate him. And by reinstate there, he meant put me back in the position that I was in 1960. It seems from the language used that he's making that distinction between his being reinstated to 1960 and the next relief that he seeks, that he should be promoted. This is relief D, thank you. Relief D, yes. That he should be promoted to the position of port follower. And pardon me, from the position of port follower to the position of a daily paid permanent worker. Now, we know that he had become a port follower sometime in 93, thank you. So he was focusing on his status in 1993 and asking the court to take him, to deal with him as at that point, and make him a daily paid permanent worker, a position higher than that of port follower. Insofar as their changes were made, my lord, what transpired even at the first instance is that 1992 was now fixed upon as a date. And subsequently in 2003, that too became a date that they would rely on, both before the Court of Appeal and in the court of first instance. By inviting the court's attention to what was happening in 2003, the appellant made it the focus of his case that something triggered his action, and that was that certain persons amongst port followers, where he now was, had been appointed to higher positions, and he was not. That's the only wrong that he complained of in 2003, or could properly complain about, that he had been promoted to the position of port follower, or appointed port follower, and there were others who themselves were port followers, and they had been improved, and he had not. It is that triggered him in 2003 to bring an action subsequently. The 1992 relief that he sought, or when he placed the Court of Appeal's focus on what was happening in 1992, could only have been a reference to a recommendation that had been made, page 281. And that recommendation is found at page 281 of the record. Sorry?
281.
No? No, not 281. If you just bear with me, please, Mills. A recommendation has been made, page R24, page 24.
I think we've seen this document before, haven't we?
Say again, please, Miller.
I think we have seen this document before.
Indeed, Miller. It's at page 24 where the recommendation had been made that he be confirmed as a lift operator, still temporary, but confirming him, so that his 1992 position could not be restored except as a temporary worker once again. And I have been belaboring this to demonstrate that throughout the comparisons of the two men, they were both temporary workers. And it is our submission that they ceased to be comparators after 1991, when Mr. Hippolyte was confirmed. May I just invite your attention to that page once again.
Page what?
Page 281.
Yes. Yes.
And a recommendation had been made there. They said his reemployment does not give effect to his effective years of service, so we are going to reemploy him treating with him as though he had come into the service in 1990, and to that the trade union had no objection. The difference that occurred in 1992 is that Mr. Hippolyte was now treated as a reinstated employee and would recover his rights to pension and gratuity if he had lost them at all. But, as the Court of Appeal properly observed, his forfeited years of service remained forfeited. He got no benefit from that. Took no seniority from his pre-incarceration years either. So that, thank you, yes, he would not have lost gratuity. Now, it has been submitted that it is at that point that they were to be treated as comparators, and that it is at that point that the Court of Appeal erred. I think I understood that to be said. Our submission is that the point of comparison ended in 1992, pardon me, when Mr. Hippolyte became or was recognized as reinstated to the position on the roll by reason of his being re-employed and given the value of his gratuity and his years of service after 1990. My Lord, if my lords are inclined to that view, you would find, therefore, that in 2003 there was even less of a comparison between the two men. By 2003, Mr. Daban, the appellant, had been increased his position, and he had gone on to become a portfolio. But Mr. Hippolyte was in another place.
In other words, you're saying that if Mr. Daban and Mr. Hippolyte are to be treated as comparators, that is for a moment in time. I mean, I appreciate that you say that they're not comparators anyway, but the change in circumstances after that moment in time cannot bring with it the right to comparative treatment, because it could be due to all manner of circumstances in relating to their employment.
Quite so, my lord.
Yeah, right. Okay, let's move on then.
And so, my lord, the Court of Appeal, we submit quite properly, having established that focus on the outcome being different. And it is a truism that the outcomes, if ever we were to get around to the question of damages or compensation, may well require some further investigation, some adjustments in the facts, some evidence as to what earnings had Mr. Daban had during the time that he was away from work, 1969 and 1980. And of course, the question of whether the delays, both on our part and on his, impact on any assessment. May I treat firstly with the delay on our part, the Port Authorities, that is. The Port Authority has said, and that has not been ruled upon, that Mr. Daban did not make himself available for work during the period 1969 to 1980. It is a fact that has been accepted that he denied that he was out of the jurisdiction, but the Port Authority, acting on what has been said by Elva Toussaint in her affidavit, claimed that he had told her that he had been out of the jurisdiction.
Yes, but that can't be revived as a justification now, can it, in light of the findings by the first instance judge and the Court of Appeal?
That he was not, those courts treated with his not being within the jurisdiction.
Well, they have found that it wasn't shown that he was not within the jurisdiction.
Precisely, my lord. But was he available for work? The answer may well turn on whether he was employed in the St. Patrick County Council or not as a casual laborer.
Well, I think perhaps you may have better points than that.
Indeed, indeed, my lord. Indeed, my lord. But Milord, I do wish to add, notwithstanding, that it is the state of mind of the port that might matter. And to them, he had communicated that he was not only not available, but out of the jurisdiction throughout that period. Milord, in light of how we've approached this case, we are saying, but those things that occurred during 1969, to 1980, are of little moment. It is what transpired thereafter when Mr. Hippolyte came within the realm of comparator. Up until 1990, there was nothing to compare Mr. Hippolyte to Mr. Daban. And Council has said, and maybe quite rightly, the Constitution is written with an open-ended fashion, in an open-ended fashion, so that one may say there is no prohibition on looking retrospectively to determine if there has been unequal treatment. In other words, if you turned up in 1990 and sought to reflect on treatment in 1980, you may well be within time for a constitutional motion. And the same may be said if you turned up in 2004. But a court may well ask, how do we treat with the delay on the part of the applicant? And with our submission that must militate against such an applicant. On the part of the applicant, the appellant, pardon me, it is to be noted that when he found employment in 1980, he made no complaint whatsoever about the position to which he was employed. And if we go back, between 1969 and 1980, he took no formal steps to have his position adjudicated upon.
Well, that's because he didn't have a comparator.
I'm sorry, Milord, I was making a slightly different point.
Right.
That it would have been open to him, no doubt, to challenge their reasons for refusing to employ him. He may have found ground on which to challenge it, but there appeared to us to be none. And in any event, the Port Authority was saying, well, we simply can't treat with you, you are not available. He took no formal steps to adjudicate upon his status between 1969 and 1980. He took no formal steps in 1980 onwards when he had been re-employed as a temporary. If he was dissatisfied, he could then have challenged it. He was once again a member of the trade union. He could have gone to the industrial court and said, I am not placed in the position where I am best suited or for which I am qualified. Thereafter, when Mr. Hippolyte came on board in 1990, once again, no formal step was taken, even on the basis that he now had a comparator, to go to either of the courts which could give him relief. He sat quietly by. Pardon me, it's exaggerated to say that he sat quietly. He did say that he made complaints from time to time. But he took no formal step to get an adjudication of what appeared to him then to be a wrong done against him. And it is those salient points we submit what the impact upon your lordship in determining whether this was not really an abuse of the process. Because we say it was. There was no comparator in existence at the times that for which he sought relief, that is to say 1980 or 1960. And whereas there was a comparator in 1992, and that we are inclined to say is not truly so, there was one in 1991, but Mr. Hippolyte had gone off in a different direction. But even if we were generous enough to say that he was a comparator in 1992, the case for the respondent is they were different categories of workers at the time. Mr. Hippolyte had gone on to other things. He had been promoted, he had been confirmed as a temporary longshoreman.
Yes, quite.
Grateful to him. Well, those are what I wish to bring to your lordship's attention on the question of, was Mr. Hippolyte a proper comparator? And can this case stand in the absence of a proper comparator?
Yes.
The next point that I have hinted upon is the delay and how it would impact on the case. But I would urge your lordships to look at it from the point of view of whether the changes in release sought do not compound the delay on the part of the appellant.
Well, it's a matter for you to make what submissions you consider are appropriate, Mr. Prescott. I mean, it's a matter for you to make such submissions as you consider to be appropriate.
Indeed.
You would have heard the exchanges between the board and Mr. Poole. It may be that you don't feel it necessary to dwell extensively on that particular topic.
No, to the contrary, I do wish to address your lordship on.
Yes, well, by all means.
They may be found in our case, in the case for the respondent, commencing at page 548.
Yes?
In paragraph 37 of that, at page 549, we make the observation that, the submission that there was no entitlement on the part of Mr. Daban to be treated as a permanent worker. It certainly was not an entitlement. He had lost his job in 1964. He was returning and seeking employment in 1969. And so there was no entitlement prior to that date. And he had had no entitlement thereafter, because in each case, the court was either engaged in an act of discretion or in the process which required them to consult with the trade union in order to make a determination. The court has made that point repeatedly, that it was required that it treat with the trade union, and this may be found in the affidavit of Toussaint and in a letter to which I will draw your lordship's attention very shortly. At paragraph 40, at page 43 of the record, commencing at paragraph 44, you will note the following. A recommendation, pardon me, maybe I should just read it, Murat, in reference to a statement made where it is admitted that a letter dated 30th April was issued by the Divisional Manager of Human Resources. It was a recommendation for the consideration by the Operations Division or the management of the respondent. That is to say, the recommendation that Mr. Daban appointed. Is that the correct word? As a portfolio.
Now, what's the particular point that you wish to make from this, Mr. Prescott?
That the paragraph goes on to say that all such recommendations required the intervention of the registration committee of the port. And in paragraph 45, they could not act without reference to the trade union.
Yes.
So that they were always prescribed by the requirement that they deal with Mr. Daban's situation against the background of the views of the trade union and of the registration committee. I make that point to say that insofar as it has been suggested by the appellant that there was an entitlement for Mr. Daban to be granted employment at any time, the answer is no. Moreover, it is our submission that post-1969, the port did not at any time regard Mr. Daban as a permanent employee. The only time that he enjoyed the permanent employee status was in 1963 to 1964, prior to his conviction.
Yes.
May I just confirm that this is the submission that I had heard? Council had said that yes, that they were an entitlement to be returned as a permanent worker. That I am urging your lordships to reject as a suggestion, because there was no such entitlement. Not only did we so submit, but we refer to the evidence of Elva Stewart-Toussaint at page 47 of the record, at paragraph 58, where she speaks specifically to him not being entitled to be classified or promoted to the position of portfolio paid permanent worker, as he had suggested.
Yes.
Then I do wish to invite your lordship's attention to the case for the appellant, and to the submission on the part of the appellant that the Court of Appeal erred when it held that the appellant and the respondent had been in receipt of the same treatment. This is to be found at page 479 of the record. And at paragraph 42.
Yes.
In the last 4 lines of paragraph 42, you'd find the Court of Appeal saying it was within the appellant's discretion to re-employ him, and it did so by offering him the same temporary employment that was offered to Mr. Hippolyte. Well, I think I've said this before, that is a reference to this, what is acknowledged in the collective agreement, that there are 4 groups of people who are collectively referred to as temporary workers. Port followers, the group to which Mr. Hippolyte had been appointed, and temporaries, capital T, temporary workers, were both in temporary employment.
Well, I think a rather different point has been made there, is it not? And that is that the outcome in the appellant's case, not the respondent's, was less favourable than for Mr. Hippolyte, was because of the difference between the positions that they occupied before.
Yes, my Lord. My Lord, the Port Authority has addressed that throughout the case by saying, firstly, that Mr. Daban could not find a proper fit within the establishment if they sought to return him to where he was in 1964, or if they sought to offer him a position similar to that he had held in 1964, because matters of seniority, etc., would have led to a disagreement, if you like, with the trade
with
union,
the unions, yes.
and would have impacted on other workers who had been there already.
Yes, well, I think we probably have that point. Thank you, Mr. Prescott.
They've made no moral judgments at all. Millard, it is our submission that it is a proper approach to this case for the Court of Appeal, having determined that they had been treated similarly, to then look at the outcome. And we are distinguishing the outcome from the treatment. Having determined that they should both become temporary, we then must look on a broader perspective to determine where can we fit Mr. Daban, where can we fit Mr. Hippolyte? What are the difficulties that we are going to be faced with? And it is the difference in their status pre-incarceration that impacted on the outcomes for them.
Right. Well, I mean, I think we've just discussed that. Yes?
I move on with the observations from the case for the appellant, which I should like your lordships to focus on. In paragraph 32, at page 536, I didn't hear it repeated today, my lord, but it remains on the record. Starting at about line 10, the sentence begins, the respondent could have sought to justify.
Yes?
But I say it had not been repeated today, but nonetheless it is on the record. It reads as follows. The respondent could have sought to justify not re-employing the appellant as a permanent employee on the basis that those whose employment is terminated as a consequence of serving a custodial sentence should have to work their way up from the bottom, and as such should only be re-employed with their names being placed at the bottom of the temporary rule. My lord, it has been said repeatedly in this case, the Port Authority had no policy that A, require them to make any moral judgments about the persons who sought re-employment, or B, on how do we treat with people who are returning from incarceration. Each of these cases was fact-based, and the distance in time between them is significant. The submissions go on to say, had the respondent advanced this argument, it would have had to have identified the legitimate aim behind such a policy.
Well, I'm sorry to interrupt, Mr. Prescott, but this case has not been espoused by Mr. Poole in his oral argument, and in any event, it's your case that there was no such policy, so the question of justifying it or identifying a legitimate aim simply doesn't arise.
Simply does not arise.
As I understand it, the reason for the inclusion in it is to give an example of how justification might have operated had there been such a policy. But since there is no such policy, I'm not sure that we're going to profit enormously by considering what might have happened had there been one. Yeah.
Well, the way to end this is to say that when we examine the evidence of the authority as to the reasons behind their treatment of the appellant during 1969 to 1980, that is to say the date by which he was re-employed, we find the thing that mattered most is where do we fit this worker now that we have decided to re-engage him. He had demanded, requested that he be replaced where he had left off. In other words, reinstated without loss of anything. The port had good reasons and they offered those justifications for not treating him in such a fashion. And we are urging the court to hold that the material differences between himself and Mr. Hippodon certainly support the steps taken by the Port Authority. So that there was no breach of his right to equality of treatment, Section 4D, between 1969 and 1980. Let us see that submission being made at page 541 in the case for the respondent.
Yes.
Now, I do not wish to address you on the question of what compensation might be like or how different it would be, but I think it would also seem that there ought to be some evidence there at some point in time.
Well, I think it's accepted by Mr. Poole that if we arrive at the question of compensation, that will be a matter for one of the courts in Trinidad and Tobago.
So, my Lord, may I then invite your Lordship's attention to the positions taken by the respondent at page 542.
Yes?
That we, conceding that the Port Authority is indeed a public authority, we are contending that it is necessary to make a judicial determination by reference to the facts as to whether the functions, in particular the employment function, is purely private. Our contention is that it is purely private, and for that I should invite your Lordship's attention to the decision of the Court of Appeal at tab 7 in Box Hill and others against the Port Authority, and in particular the ruling of Justice Barrow at paragraph 51, page 681. I will in summary, I'll do the summary first. In summary, what Justice Barrow concedes is that there may or may not be a public law element in the functions of public authorities, such as the Port Authority. But he says the private law nature, paragraph 52 of their acts will not be the sole basis by which the motion will be judged. The decision will turn on the facts and circumstances of the case. So Justice Barrow, Court of Appeal Judge Barrow, conceded that there may be a private law element in the actions of the Port Authority and other statutory authorities, but that it would be necessary to make a judicial determination based on the facts before us. It is our submission that employment decisions at the level of staff within the public authority, and I'm distinguishing staff from officers, employment decisions are a private function.
Yes, but what Mr. Poole argues is that Justice of Appeal Barrow made it clear that when a decision taken in the employment context brought about unequal treatment between employees contrary to the Constitution, that circumstance made the action of the employer a public law action.
There's no denying that to be the case. However, in this particular case, and I regret that I have to go over those schools, as between 1969 and 1980, there was no such comparator and therefore no treatment of which the Port Authority could be blamed. No difference in treatment. The same continued to apply until 1990. And at that moment in 1990, when Mr. Hippolyte was employed, one may say, here are comparators. Are they being treated equally? We have contended that the Court of Appeal quite properly said that they were being treated equally.
Well, it might be a convenient time, Mr. Prescott. We've now passed 1 o'clock, and we sit again at 2.
Most grateful to you, Madam.
Thank you.